Hi, Amber Zinner here with the Miller Elder Law Firm, and today I'm continuing our Smart Estate Planning series with the next in line, which is navigating the Florida probate process, and a quick step-by-step on what that looks like and what we can expect. So jumping right into it, it's really broken down into about 3 segments, if you will, and they're very, very general. So opening the estate, administering the estate, and then closing the estate, right? Easy to think about. Now, this process, though, there are steps in the middle, and it can take up to a year, which is not the best thing in the world to have to go through. However, it's not that complicated depending on your circumstances. Opening the estate, we're really looking at gathering information on what we know are the assets, if there are unknowns, and what that process we're going to be going through looks like, because there are a couple different types of probates. The most common is what we would refer to as our formal administration. And that would be where we actually need to get a person representative, or executor, as they may be called elsewhere, the ability to operate on behalf of the estate, so appointed by the court. That process, opening the estate, can take around 6 to 8 weeks, give or take, just depending on what we're missing or what we need and what it takes to get that. So death certificates, if there's a will, a last will and testament, or if we need to do a copy or admit a copy. It just depends on what the specific circumstances are that we're looking to open that estate. The second part there is administering the estate, which can be broken down really into a couple steps. So the first thing we generally want to do on an estate is an inventory. Once we have our personal representative appointed, they have the ability to now go and locate those assets, specifics, account numbers, how much is in the accounts, if there are assets we didn't know about before, locating those, so that we can do an inventory for the court to show the court what is actually in the estate that needs to go through probate. From there, we at the same time generally want to do around the same time what we call a notice to creditors, and that gets published into the local newspaper in the area where our loved one passed away. And it puts those creditors on notice in order to shorten the window for them to file a claim. So if there are debts or other liabilities involved, they get that 3-month period instead of 2 years in order to file their claim. That process is 3 months, and then another month to do the notice to the court of anyone who came forward and what those debts look like. So about a 4-month process there. And then we go to more generally our accounting and distribution. This is the portion of the probate process where we get to actually finalize it. So if an accounting is needed, doing an accounting of what was in the estate, where and what those adjustments look like, if there are any, if there were adjustments or investment accounts or things like that, and what the end results are at the end of the probate, costs for the probate, all of that included. And then we can distribute to our beneficiaries. So all in all, the process can take about a year, again, depending on your circumstances. And this would be for a formal administration. So always important to have this conversation, see if you need a probate or what that looks like and what needs to be done in order to get everything where it needs to go as smoothly as possible with an attorney. Thank you, Amber Zinner, Miller Elder Law Firm again.